It does seem, well, maybe a little too coincidental, doesn't it? That just as Republicans got that Supreme Court supermajority in 2020, the court suddenly kind of realized the Constitution required the country to adopt the Republican platform on abortion, voting rights, regulation, campaign finance, a whole lot of stuff.
It's a striking observation to start with, for sure.
Absolutely. So today, let's unpack that. We're looking at a really thought-provoking new book, analyzing how maybe feelings and political goals could be shaping legal interpretations.
Right. How these underlying currents might influence things.
And just a note before we jump in, if you're interested in exploring this book's analysis even further, maybe through an AI lens that gets you thinking, check out Mindful Moments on our YouTube channel.
Okay, so where does the book start this analysis?
Well, it dives right into this idea of minority rule.
Yes. The argument that because of how the Constitution divides power among states and, population shifts, the Republican Party can hold significant power even if they represent a smaller slice of the actual population nationwide.
And the book draws a direct line from that to the Supreme Court.
It does. It argues that the court's conservative supermajority now often lands on the Republican side of things, even on issues where that viewpoint isn't broadly popular.
Any specific examples given early on?
Yeah, it mentions the court siding with figures the book calls wannabe coup-doers in cases related to January 6, noting Justice Alito was in the majority there.
So the argument isn't just about political power, but how the system structure might enable that influence on the court.
Exactly. That's the core idea, how a less popular party, nationally speaking, can still exert major influence through the judicial branch. It feels counterintuitive, but the book lays out how it might work.
The book uses some pretty vivid language, too. I saw a mention of the Consurrection. What's that about?
Yes. It's an analogy, obviously, from the Barbie movie. The book uses Consurrection to describe the overturning of Roe v. Wade.
Okay, drawing a parallel between Ken trying to impose patriarchy on Barbie land and the Dobbs decision.
That's the idea. The book argues the Dobbs decision was fundamentally about trying to restore a more patriarchal structure in society.
And how does it connect that to legal reasoning?
It suggests that feelings about feminism, about changing gender roles, were sort of harnessed politically by Republicans.
Okay.
And then the book argues those sentiments were translated into legal outcomes using originalism as the tool, interpreting the Constitution based on its supposed original meaning.
Does the book offer historical context for this kind of viewpoint influencing law?
Oh, absolutely. It digs into past Supreme Court decisions that were explicitly patriarchal, cases that stopped women from voting or even from being lawyers.
Right, I remember reading about those.
There was one justice quoted arguing women were just unfit for many jobs, that female independence was repugnant. It even mentions upholding a poll tax specifically for women voters back in 1937, basically because their role was seen as baby makers.
Wow. Even banning women from being bartenders in the late 40s.
Exactly. So the book uses this history to argue that seemingly neutral legal ideas like originalism can sometimes be used to, prop up older biases.
But didn't the court's view on sex discrimination change over time?
It did, thankfully. The book contrasts those old rulings with later ones that started looking skeptically at sex discrimination, recognizing it often stemmed from this idea of romantic paternalism.
Which sounds nice, but actually limited women.
Precisely. It caged women, as the book puts it. Interestingly, it notes Justice Rehnquist often dissented in those later cases, still thinking differential treatment based on sex was mostly okay.
So that sets the stage for understanding the book's take on Roe's reversal.
Right. It frames it within that longer history of evolving views and resistance to that evolution.
The book also talks about specific political strategies, particularly around abortion.
Yes. It analyzes how the Republican Party made a very strategic appeal to religious Catholic and evangelical voters. Opposing abortion and the Equal Rights Amendment became central to that.
And that strategy worked, at least in mobilizing those specific groups.
It definitely did mobilize a large segment of religious voters, according to the book's analysis.
But the book points out a downside to that strategy, too.
A major one. It argues that while it won over certain religious voters, it cost the party support among women more broadly.
Is there data on that?
Yeah, it cites a 2023 poll from a Republican-aligned group, actually, showing 71% of suburban women were against getting rid of constitutional protections for abortion.
71%. That's significant.
Very. And this is where the book brings in this idea of vibes. These underlying feelings or sentiments shaping outcomes.
Okay, tell me more about these vibes. How do they connect to legal interpretation?
Well, the book suggests these aren't explicit legal arguments, but more like background sentiments that can make certain interpretations feel more natural or acceptable than others.
Like cultural undercurrents.
Kind of. It points to examples from Republican rhetoric, dismissive comments like calling opponents cat ladies, or talk about returning to a time before women could vote, as illustrating these underlying feelings about gender roles and power.
So these vibes create a sort of context.
That's the argument. A context where certain legal arguments, maybe ones rooted in originalism that lead to outcomes aligning with those feelings, gain more traction.
Speaking of originalism, the book traces its rise in the 1980s. What was behind that, according to the analysis?
The book frames its rise partly as a pushback against the more progressive decisions of the earlier Warren Court era, especially decisions extending rights for women and minorities.
A conservative reaction.
Essentially, yes. It mentions the founding of the Federalist Society in '82, noting it grew out of a sense among conservative law students and professors that they were, ideologically isolated.
And the book connects this rise of originalism to concrete political aims.
Very directly. It argues the Reagan administration explicitly linked originalism to their goal of restoring traditional family values, and restricting abortion was key to that.
So it wasn't just abstract legal theory.
Not according to the book. It cites Attorney General Ed Meese's 1985 speech, where he basically pitched originalism as the antidote to what he called the radical egalitarianism of the Warren Court, which included things like the right to contraception, foundational to Roe.
Interesting. So limiting abortion became almost synonymous with originalism in the public mind.
The book suggests that, even for people who didn't know the legal nuances, that promise became a big part of what originalism seemed to stand for.
Let's shift to LGBTQ plus equality. The book argues similar dynamics are at play there, underlying feelings driving legal changes.
Yes, it argues that legal resistance to LGBTQ plus rights is often rooted in opposition to earlier civil rights movements and, frankly, feelings against LGBTQ plus equality itself.
And the Republican Party embraced that opposition?
Strategically, yes, framing it often as protecting religious freedom.
Does the book point to specific Supreme Court cases here?
It does. Cases like Masterpiece Cake Shop the Baker, who refused a cake for a same-sex wedding, and 303 Creative, the web designer case.
Right.
The book argues these cases show the court sort of chipping away at LGBTQ plus equality by prioritizing religious freedom or free speech claims. It suggests the court is drawing a line between discriminating based on status, being gay, and discriminating based on actions associated with being gay.
A fine line.
A very fine line, critics would say. The book also notes the Texas Republican Party platform literally calling for Obergefell, the same-sex marriage decision, to be nullified.
Wow. Okay, what about voting rights? How do these alleged conservative grievances impact decisions there, according to the book?
The book argues they've had a huge impact. It suggests the court has shifted its focus heavily onto the intent behind voting laws rather than just their discriminatory effect.
Making it harder to challenge laws that disproportionately harm minority voters, even if discrimination wasn't the stated goal.
Exactly. Shelby County v. Holder is the big example, of course, the case that gutted a core part of the Voting Rights Act.
Because the court felt it unfairly targeted the South.
The book argues the court basically bought into that long-standing Republican objection, and then cases like Brnovich made it even tougher to prove unintentional discrimination under the remaining parts of the act.
Any other examples of this perspective influencing judgments?
The book mentions a comment by Justice Thomas during arguments about Trump's eligibility for office. He referred to Reconstruction as retaliating against the South. The book presents this as an example of how a particular view of history can shape legal thinking.
Let's touch on economic inequality and campaign finance. The book suggests the court shows sympathy for the powerful.
That's a key argument. It points to decisions like Citizens United.
The campaign finance case.
Right, allowing unlimited political spending by corporations and unions. The book argues this overwhelmingly helps the wealthy and conservative candidates, and that the court basically equates having more money to buy a bigger megaphone with free speech equality.
And what about corruption?
The book suggests there's a kind of vibe that access to powerful people, even if you buy that access through donations, isn't really seen as corrupt by the current court majority.
Okay, one last major area the book covers. The administrative state.
Well,
what's the issue there?
This refers to federal agencies, EPA, SEC, FDA, etc. There's long been Republican opposition to the power delegated to these agencies by Congress.
Because they make regulations?
Exactly. The book talks about a non-delegation vibe, a skepticism towards Congress handing over authority. And while it's not a strict rule, the court has increasingly used something called the major questions doctrine.
What does that doctrine do?
It basically allows the court to say that for really big, politically significant issues, agencies need super clear, explicit permission from Congress to act, even if the existing law seems to cover it.
So lets the court step in more often.
The book argues, yes, it lets the court effectively override agency actions based on essentially Republican objections to the regulation, looking past the actual text of the law in some cases.
So pulling it all together, what's the main takeaway the book wants you to consider?
The core thesis is pretty clear, that feelings, these conservative grievances, and specific Republican political goals have deeply influenced recent Supreme Court decisions, and that these decisions often don't line up with what most of the public thinks, or even with long-standing legal principles.
It's certainly a provocative analysis. This has been a really fascinating look into the book's arguments. And again, for those of you who want to explore these ideas further, maybe get different perspectives, do check out our podcasts for more discussions.
And don't forget Mindful Moments on our YouTube channel for those AI-powered book insights we mentioned, great for sparking more thought.
Absolutely. The book ends with a pretty direct message. Friends shouldn't let friends remain in the dark about the Supreme Court. It really highlights how important it is for all of us to understand what the court does and how it affects us.
It's a call to pay attention, to discuss these things openly, and really think critically about the court's role.
So if this discussion got you thinking, please subscribe. Share it with someone you think would find it interesting. There's a link in the show notes if you want to grab the book and read it yourself.
And most importantly, keep thinking critically about all this information, about the arguments presented, and about the huge role the courts play in our society.